Good morning, I'm Rupak. Today I'm here to talk on rights of migrant workers under international human rights law. To begin with, I'll start with the learning outcome of this module. This module will acquaint you with the patterns of international labor migration, various forms of human rights violation faced by the migrant laborers during their journey in search of a job outside his or her country. It will give you a clear picture of the different sets of rights available for regular as well as irregular migrants under various human rights instruments, as well as the labor rights under the International Labour Organization's labor conventions. The rights ensured under the United Nations Migrant Workers Convention and the pros and the cons of this convention will be discussed elaborately. To have an understanding of the structure of the subject, I'll start with the outline. I'll begin with an introduction, then I'll go into different types of migration and human rights violations faced by migrant workers, the rights guaranteed under different international human rights instruments, International Labour Organization Convention on the Migrant Workers, International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, UN or otherwise called as UN Migrant Workers Convention. Under that, I'll be talking on obligations of state of origin and state of employment, and I will go to interstate cooperation and the Committee on the Protection of the Rights of All Migrant Workers and Members of Their Families, and I'll conclude the outline. Let me begin with a quote by Kofi Annan, the former UN Secretary General. Migration is the courageous will expressed by a person to overcome his extreme conditions at home. Now, what are the world offering for those people who expresses that will? You can see in these pictures how extreme conditions that they are working on. The congested labor camps that you can see on this photo shows the extreme conditions in which they are accommodated. History of humankind is a history of migration. People have migrated in search of water, fertile land, food resources, etc. Then we have a history of forced migration for labor on the other side, which was known as slavery, which formed the history of colonization. The story of the most developed nations in the world, especially United States of America, is built with the sweat and blood of the slaves from the continent of Africa. Most of the civilizations in the world has a history of slavery and slave trade. Though the prohibition of slavery is recognized as peremptory norm of international law, it has reappeared in various forms through forced labor, bonded labor, etc. The growing pace of globalization has increased the rate of economic migration in the world in the last 20 years. Unemployment, increasing poverty, population explosion, adverse domestic political situations, etc., has forced the people in the developing countries to seek work in the developed countries. And on the other hand, the economic growth in the developed countries has increased the demand for labor, especially unskilled labor. Other reasons for the demand of labor in the developed countries are there are falling fertility rates in their population and increasing life expectancy because of rise in their living standards due to the development. Now, to go into the statistics, according to the International Labour Organization, there are approximately 175 million migrants around the world, and roughly half of them are migrant workers. Of these migrant workers, around 15% are estimated to have an irregular status, and women make up almost half of these migrants. And another significant fact is that the migrant workers contribute to the economies of their host countries. The remittances that they send home help to boost the economies of their countries of origin. And on the other hand, the world's 10 richest economies by real gross domestic product, or we call RGDP per capita, like Qatar, Luxembourg, Macau and Singapore, they have sizable population of foreign migrant workers that have contributed greatly to their growth. In the following table, you will find the statistics which is provided by World Bank. To have an understanding of their contributions, in 2014, international migrants from developing countries are expected to send $436 billion in remittances to their home countries, which is an increase of 7.8% over the 2013 volume of 404 billion, and these contributions are increasing every year. Now, yet with these facts, at the same time the migrant workers enjoy little social protection and they are highly vulnerable to exploitation and severe human rights violations like human trafficking and slavery. They have to face all of this. On the other hand, different laws are brought by the developed countries to delegitimize the status of migrant workers as regular migrants in order to avoid the minimum provisions through various social security measures. Now, we need to understand the different patterns of migration. For the purpose of analysis, there are two categories of migrants. We call it regular migrants and irregular migrants. In case of regular migration, there can be persons who have a lawful entry to the country, holding an appropriate visa and a work permit to take up a regular employment in the host country. They are called the regular migrants. And the irregular migration, which comprises of different situations. Now, we can define irregular migrant as who lacks legal status in a transit or host country, one who entered a state without authorization or entered a country legally but then lost the permission to remain. Now, there can be different situations of irregular migrations. The first one can be individuals who are trafficked to another country. Then they can also be smuggled across borders, traveling to another countries voluntarily but through illegal channels. In some cases, individuals seeking refugee status can also enter the territory through irregular manner, and they later attain the migrant labor status, but irregular. In another situation, the persons who have entered the country lawfully, but after the expiry of visa, they overstay in that country and engages in irregular employment. Now, we'll go on to check what are the human rights violations faced by migrant workers. During their journey to another country illegally or legally, migrants are often kidnapped for ransom and torture by the human traffickers and the smugglers. And sometimes, even in normal situations, they have to face the ill treatment by the immigration authorities and the border security forces. Now, once they are out of the country and reaches another country after undergoing all these extreme conditions, and finally somehow they manage to acquire a job. Now, what is in store for them? The lack of basic workplace rights and protections like arbitrary deduction of wages, underpayment, late payment, and sometimes non-payment of wages, and longer hours of work than the nationals who work in the same job, and the poor safety standards, as we already seen the picture in the beginning. The poor safety standards of the workers made most of them in dangerous situations. Now, when you take the situation of accommodation, most of them are offered substandard accommodation in which the rooms would be congested with many laborers living in a small space, as I showed in the picture in the beginning. There are limited or in some instances no social security measures are provided for them. And from the employer to the supervisor, they often have to face threats verbal abuses, beatings and intimidation in course of their work to persuade them to do more work in a less time. And another case of major human rights violations reported are the confiscation of their passports and visas by the employer in order to prevent the worker from searching better jobs. Now, ILO recognizes this practice of retaining identity documents as one of the key characteristics of modern day slavery and forced labor. Another way of suppression of the rights are prohibition on workers' unions and thereby avoiding any scope of collective bargaining by the workers. Now, worse situations are the physical atrocities that they have to face, like sexual assault, rape, and the women and children often end up in highly abusive and exploitative situations. In some cases, it even ends in the death of the workers, and in such cases, sending the dead body back to home is not taken care of by the employer, and sometimes they are buried there itself without proper ceremonies. In some countries, the workers also have to face racial and other forms of discrimination. And to make things worse, in most situations, there are no redress mechanisms available for these workers. In some cases of human rights violations that we all know, the first picture that comes out to the mind is the labor situation in the Middle East countries, where there is a huge flow of migrant workers and the situation is mostly horrible. All the situations of violations that we already discussed in the previous slides applies to the labor situation in most of the Middle East countries. You can see in the graph, most workers from the South Asia, especially India, goes to Middle East for their jobs. An illegal system of contract labor which is prevalent in most of the Middle East countries. It's called kafala or sponsorship system that they call, and it is nothing more than the modern day slavery. Now, what is a kafala system? Kafala system ties a migrant worker's legal status to a sponsoring employer, requiring workers to get an exit visa from that sponsor to leave the country. And various human rights organizations reported human rights violation in Qatar in the infrastructure building projects for the 2022 World Cup football. Now, Amnesty International estimates 94% of workers in Qatar are foreign nationals, and there are alarmingly high rates of migrant worker deaths and a litany of human rights abuses in Qatar due to the lack of protection. And when you go to West, countries like UK has also come up with a similar kafala like system covered in different names like overseas domestic worker visa. It has also tied the migrant domestic workers to their employers and limited their period of legal residence in the UK to 6 months, and they can also not go out and take better jobs. Now, this graph will show you the movement of workers mostly to the Middle East countries. Now, the migrant domestic workers are the most abused category of the migrant workers in most countries. UN Special Rapporteur on Contemporary Forms of Slavery, Gulnara Shahinian, in its report on contemporary forms of slavery, including its causes and consequences, has cited that migrant domestic workers employed by diplomats are a particular vulnerable group. Firstly, their visa status typically depends on continued employment by the diplomat, and they are therefore not free to change employers in case of exploitation. Secondly, diplomatic immunities and privileges shield diplomats from the enforcement of national legislation. Now, we know the recent issue related to the arrest of Indian diplomat, consular officer Devyani Kobakrade. This throws the light into the violations of the labor rights faced by the migrant domestic workers. Now, we understood the different violations that happens to a migrant laborer. Now, what are the rights guaranteed under international human rights instruments? We all know that there is a slogan by the human rights activists around the world: migrant rights are human rights. The key principles of human rights are universality, which means that application of human rights is universal and they are indivisible. Inalienability, which means one cannot take away human rights in any instance, even though there are exceptions. And equality and non-discrimination. And these principles gave the migrant workers necessary protection in any part of the world. UDHR, or Universal Declaration of Human Rights, the Article 1 talks about universality and Article 2 talks about non-discrimination. And the International Covenant on Civil and Political Rights, or ICCPR, it defines the basic rights, and Article 2(1) of the ICCPR provides for the non-discrimination. The General Comment number 15 of Human Rights Committee explains the position of the aliens under the covenant, which is significant. It says the covenant does not recognize the rights of aliens to enter or reside in the territory of state party, but continues by stating that, however, once aliens are allowed to enter the territory of a state party, they are entitled to the rights set out in the covenant. Unlike ICCPR, International Covenant on Economic, Social and Cultural Rights, or ICESCR, it does not distinguish between documented or undocumented migrants. The Committee on the Economic, Social and Cultural Rights in its general comment states that the reference to other status in the Article 2, it includes the grounds of nationality. The only restriction is provided in Article 2(3), which gives concession to developed countries in determining the extent that they would guarantee the economic rights recognized in the present convention to non-nationals, with due regard to human rights and their national economy. Now, Article 1(2) of the International Convention on the Elimination of Racial Discrimination states that conventions shall not apply to distinctions, exclusions, restrictions or preferences made by a state party to this convention between citizens and non-citizens. In General Recommendation 30, it goes on further to say that although some rights can be limited to citizens of a state, human rights are in principle to be enjoyed by all persons. Now, with regard to irregular migrants, CERD addresses the states to ensure the legislative guarantees against racial discrimination. It applies to non-citizens regardless of their immigration status. Now, there are other relevant instruments like Slavery Convention of 1926 under the League of Nations. There are supplementary conventions on the abolition of slavery, the slave trade, institutions and practices similar to slavery of 1956. Then there is a UN General Assembly Declaration on the human rights of individuals who are not nationals of the country in which they live. And we know there is a declaration and program of action of the World Conference Against Racism, Racial Discrimination, Xenophobia and Related Intolerance. Then there is a resolution of the UN Commission on Human Rights on the human rights of migrations in 2005. And there is a resolution of the UN General Assembly on protection of migrants in 2004. But understanding the different labor rights available for the migrant laborers, we need to go into the lawmaking done on the major platform of labor rights, that's the International Labour Organization. The issue of migrant labor has been one of the core items on the ILO's agenda. In the Declaration of Philadelphia in 1944, it restated its traditional objectives of ILO. It states that the solemn obligation of ILO is to further programs which will achieve, in clause it says, the provision as means to the attainment of this end and under adequate guarantees for all concerned of facilities of training and the transfer of labor, including migration for employment and settlement. Now, there is a Declaration of Fundamental Rights and Principles at Work in 1998. It also reaffirms the obligation stated in the objective which is said earlier. With regard to the treaty making, ILO has established a number of conventions that outline the labor rights of migrant workers. Migration for Employment Convention in 1948, which is commonly known as C97, with 47 ratifications, and Migrant Workers Supplementary Provisions Convention 1975, which is commonly known as C143, which has 23 ratifications. And these conventions are supplemented by two non-binding recommendations, that is migration for employment recommendation, which is revised, and migration workers recommendation in 1975. Now C-97, which establishes the principle of equal treatment between nationals and non-nationals. It spoke about the immense potential in the harmonious redistribution of manpower in different countries. Unlike C-97, C-147 only dealt with undocumented migrants. Part 2 of the convention provides for the equality of treatment between irregular and regular migrants with respect to certain rights only. Article 3 provides for measures to determine and suppress clandestine movements of migrants for employment and illegal employment of migrants, and to punish the organizers of such movements and the employers of such migrants to prevent the abuses. There are also provisions in the convention for the family reunification, and the definition given for the migrant workers family is extended to the dependent parents, and it used the word spouse, which is a more general neuter term which was not used in the 1949 convention. Language of human rights is not clearly and substantially used, though the 1975 convention speaks about the human rights irrespective of immigration status. To fill the gap, we know that there is an international convention on the protection of the rights of all migrant workers and members of their families. The focus of migrant labor rights on labor and the regulatory aspect of it shifted towards a human rights language with this convention. The preamble to the convention recognizes that the human problems involved in migration are even more serious in the case of irregular migration. Part 3 of the convention sets out the rights belonging to all migrant workers and members of their families irrespective of their migration status. It includes the right to life, which is provided in Article 9, the prohibition against cruel, inhuman or degrading treatment or punishment, which is in Article 10, the prohibition against slavery or servitude and forced or compulsory labor in Article 11, the right to equality with nationals before courts and tribunals, the right not to have identity documents confiscated is given in Article 21, the right to equal treatment with regard to remuneration, other conditions and terms of employment and social security is given in Article 25 and 27. And with regarding to the collective bargaining, the right to join and take part meetings and activities of trade unions is also provided under Article 26. And in addition to this, there are a set of rights available specific to regular migrants. That's the right to form associations and trade unions. Article 40 says this. Article 43 provides for the right to equal treatment with nationals in relation to access to educational institutions, vocational training, housing schemes and social and health services. The right to seek alternative employment in case of termination of work contract prior to the expiration of the work permit is laid down in Article 51. And 52 ensures the right to freely choose their remunerated activity after 5 years of residence in the host country. The right of equality of treatment with citizens in respect of protection against dismissal, employment benefits and access to public work schemes, which is intended to combat unemployment, is provided in Article 54. And it also provides for the right to redress in case of violation of the terms of employment contract. Now, this convention also has provided for obligations of state of origin and the state of employment. The state of origin from which the migrant laborer moves, it has the foremost obligation first to allow the person seeking employment abroad and to leave and enter their country to the country of origin, which is provided in Article 8. And before their departure to states of employment, document migrant workers and members of their families should be fully informed of all conditions applicable to their admission, stay and employment as well. It is provided in Article 37. The state has to ensure them to participate in public affairs, vote and participate in the elections in their home countries. They also have to provide adequate consular and other services. The state should regulate the recruitment of workers for overseas employment by different restrictions in order to avoid false movement. It has to assist in the orderly return to their home country and to promote adequate economic conditions for their resettlement and their social and cultural reintegration. Now, what is the obligations of the state of employment? The state of employment should protect the liberty and security of migrant workers and members of their families, which is provided in Article 9 and 10 and 11. It should give protection against arbitrary detention, violence and harassment. It ensure standard health conditions, and it should also ensure protection against arbitrary deprivation of property, and if done, they should be provided with adequate and appropriate compensation. The migrant workers should be provided equal treatment with the nationals before the state missionary and before the courts of laws and tribunals. It is provided in Article 18. The states have to provide the right to access of education to their children. They should be given the right to form trade unions, and they should be provided with the rights to be protected against the confiscation of necessary documents. This is in Article 24. And in this convention, they also have a right of family reunification in the state of employment, which is provided under Article 44. And this conventions also seek for interstate cooperation, which is provided in part 6 of the convention. States have obligation to consult and cooperate to promote sound, equitable and humane migration conditions. States should also collaborate to prevent and eliminate irregular migration. States should cooperate to punish traffickers, smugglers and those who exploit the migrant workers, which includes employers, agents, etc. Now, what are the treaty mechanisms available under this convention? There is a committee on the protection of the rights of all migrant workers and members of their families. Article 72 provides for it. It establishes a treaty body, which is the committee, which monitors the implementation of the convention. And this committee consists of 14 independent experts. The state parties are obliged to report regularly, which means 1 year after becoming party to the convention and every 5 years thereafter, to this committee, which will review it in a public session. And the committee will make concluding observations upon this review. And there is a complaints procedure which has to be followed, and it includes an optional individual complaints mechanism, which means that individuals can approach the complaint mechanism but with a prior approval of the state. Now, there is a mechanism for state complaints procedure, whereby any state can approach the complaint mechanism, citing that some states are not fulfilling the obligations of the convention. The state complaint mechanism is important in this convention because every state has to ensure the rights of their countrymen who is working in other countries. And the general comments made by this committee on different provisions of the convention, by interpreting it, it widens the scope of the different provisions also. To have a critical analysis, the UN Migrant Workers Convention enhanced the protection of migrant workers not only with regard to labor rights but in the realm of human rights. Some scholars have critiqued this role of convention in limiting certain existing rights. Though it laid down protection for undocumented workers, it created a different sets of rights from that of regular workers. The Migrant Workers Convention has attracted only very few ratifications. The countries that have ratified the conventions are mostly countries of immigration rather than immigration, and this is the major drawback of this convention. And there are different misconceptions about this convention. One of the major arguments is that the ratification of the convention would create large inflow of irregular migrants and the state would be forced to protect them. But the truth is that this convention contains a state sovereignty clause, which is Article 79 in parts 8, which states nothing in the present convention shall affect the right of each state party to establish the criteria governing the admission of migrant workers. Concerning other matters related to their legal situation and treatment as migrant workers and members of their families, state parties shall be subject to the limitations set forth in this present convention, which clearly gives that the state has the leverage in regulating the migrants. And the fact shows that the migration of labor has always been happening, both legally and illegally. Lame arguments are put forward by the states in order to avoid any form of commitments. But the states cannot avoid the obligations under the general human rights instruments, in which many of them has acquired the customary international law status. Acts like slavery, even in new forms, is a violation of peremptory norms of international law. The other major political hurdle in this campaign is that it will create losing of the jobs of nationals, and it will increase the levels of unemployment in these countries. The legislations like Nitakat or workforce localization program brought out by the Middle East countries like Saudi Arabia are to counter such campaigns by protecting the jobs of nationals. But different statistics shows that the migrant workers are filling the jobs left vacant or not done by the domestic nationals. With all these regulations, we are seeing there is a major flow of migrant workers still happening to these countries. There is a lack of awareness, promotion and inadequate knowledge about this convention. The other major criticism is the lengthiness and the complexity of the different provisions, and it demands significant changes of the national legislations of the ratifying states. Now, some also argue that the slowdown in the world economy is also regarded as a reason for the shyness of the states in ratifying these conventions, but these are not the real significant reasons. The migrant workers, if subjected to the realm of human rights, they can critically reshape the process of migration. It is considered by the states as affecting their sovereignty and national interest. The impacts of the national population is cited as the major reason, and the cost of granting specific right to migrant workers is calculated high, and the states don't want to get burdened by the economic cost. During the drafting process itself, some of the major host countries have indicated that they will not ratify the convention, and the mixing up of the convention with the regime of transnational organized crime of human trafficking and human smuggling also has to be seen with the state's national interest in controlling the migration. But the national interest and economic impacts are not the concerns of the human rights regime. The Migrant Workers Convention is a restatement of the different human rights already ensured by different human rights instruments. Thank you.